The International Court of Justice is set to hand down an order tomorrow on South Africa's request that Israel immediately suspend its military operations in Gaza.
The petition to the court is asking for provisional measures in a case that claims that Israel's military actions in Gaza amount to acts of genocide as stipulated in the 1948 Convention on the Prevention of the Crime of Genocide.
The country launched an attack after the Hamas massacre of Israeli civilians on October the 7th.
South Africa wants the Hague-based court to grant interim injunctions that could fundamentally shift the character of Israel's devastating Gaza offensive.
It's statements like these from the highest echelons of the United Nations that in part set the ICJ case in motion. This during a Security Council meeting on Tuesday, almost 2 weeks after South Africa led arguments in The Hague.
The entire population of Gaza is enduring destruction at a scale and speed without parallel in recent history. Nothing can justify the collective punishment of the Palestinian people. With winter bearing down, 2.2 million Palestinians in Gaza face inhumane, squalid conditions, struggling to simply make it through another day without proper shelter, heating, sanitary facilities, food and drinking water. Everyone in Gaza is hungry, with a quarter of Gaza's population, more than 500,000 people, grappling with catastrophic levels of food insecurity.
While the broader claim of Israel's obligations under the 1948 treaty are ventilated, South Africa is asking the court to grant interim orders, including that Israel take reasonable measures to prevent the genocide of Palestinians, ensure that the displaced are able to return to their homes and have access to humanitarian assistance, while taking the necessary steps to punish those involved in the alleged genocide. Pretoria's legal team also called for the preservation of evidence to Israel's military activities in Gaza.
Article 2 of the 1948 Convention refers to genocide as acts committed with the intent to destroy in whole or in part a national, ethnic, racial or religious group by killing members of the group, causing serious bodily or mental harm to members of the said group, deliberately inflicting conditions of life calculated to bring about the group's physical destruction, imposing measures to prevent births within the group, and forcibly transferring children of the group to another group. As the 17 judges of the UN court weigh the accusations and Israel's unambiguous rejection thereof.
The ICJ has discretion into what kind of provisional measure it imposes. It does not necessarily have to follow those precisely asked by South Africa. So it could also opt to order Israel to impose, to have a humanitarian ceasefire. And in addition to that, South Africa has also requested for other kinds of provisional measures, such as the obligation for Israel to do what it can to make sure that the Palestinians have access to food, to water, to humanitarian assistance, to medical assistance. So it may be likely that the court also issues those kinds of orders, and possibly also that it orders Israel not to do anything that may aggravate the situation.
Israel has rejected the charge of genocide as false and grossly distorted, arguing in the main that it was acting in self-defense in an ongoing war with Hamas, not the Palestinian people, urging the court to reject the case as groundless.
There's a legal discussion whether indeed Israel has the right to self-defense in this situation. In the War Advisory Opinion of 2004, the court ruled that the right to self-defense did not have applicability there. So it is contested whether Israel has indeed the right to self-defense. But even if Israel had the right to self-defense, this is not a blanco check. So even if the court would go along with that argument, which it is not necessarily likely, even then that is not sufficient to rebut all the claims that South Africa is making.
Before ordering any provisional measures, the court on Friday must first determine whether it has jurisdiction in the matter before any hearings on the broader merits of the case take place. It must confirm that there is a dispute between the two signatories to the Genocide Convention and that there is in fact an urgent basis to order any immediate measures to be implemented by the state involved in this war. Sherwin Bryce-Pease, SABC News, New York.
And Sherwin joins us now from the UN headquarters in New York, where this case is being watched closely. Sherwin, good evening. What are officials saying at the UN, saying ahead of this case in The Hague? And probably it's worth noting that while South Africa has received a broad spectrum of political support for its case, there are still key detractors, including from countries like the US, where you are.
Yeah, Iman, UN officials are a bit tight-lipped. I'll read you what the Secretary General spokesperson Stefan Dujarric said about the case. He says, we're of course aware of the case and we'll be watching what happens in court, but the ICJ, the International Court of Justice, is independent of the Secretary General. He has no impact, no influence over them. They are independent, and so we have no comment on proceedings. But a key word there is we'll be watching this case. And what will UN officials be watching for in the main, Iman? If this court, in terms of proposed provisional measures, provides some humanitarian relief in terms of what has been a key demand from UN officials for an immediate humanitarian ceasefire, right? You've seen the humanitarian deficits on the ground in Gaza. You have seen a constant train, a queue of UN officials calling for humanitarian relief to enter Gaza at scale. In fact, there is a UN Security Council resolution that passed in December 2023, just a few weeks ago, Iman, that says the following. It reaffirms the obligations of parties to the conflict under international humanitarian law regarding the provision of humanitarian assistance, demands that they allow, facilitate and enable the immediate, safe and unhindered delivery of humanitarian assistance at scale. And that's a key element, yes. Yes, there's been aid getting into Gaza, but not at scale to really have a commensurate impact in terms of the needs on the ground. So the UN will certainly be watching for any kind of humanitarian relief so that they can really tackle the root causes of what the population in Gaza is facing. In addition to that, as you correctly point out, you have some detractors to South Africa's case. You have a number of supporters, no less from the Organization of Islamic Cooperation. You've seen the Arab League come out in support of this. Key countries including Malaysia, Iran, Turkey, Jordan, Bolivia, Colombia, Brazil, Namibia, among others. But then you have key Western states led by the United States, the United Kingdom, Canada, Germany, France, Austria, the Czech Republic and Hungary saying they do not support the premise of the case. The Americans have, for example, said that the case is meritless, counterproductive and completely without any basis in fact whatsoever. Whether or not South Africa gets political support from various countries is essentially irrelevant in terms of what the judges are going to hand down, right? And being a member state of the United Nations makes you an ipso facto signatory to the statute that created the International Court of Justice. So countries are going to have to comply with an order that is handed down by this court, and we shall see what they have to say come Friday afternoon, Iman.
So many connected global interests in this particular case and in the decision tomorrow. And speaking of, as we await the court's decision, the question of implementation of possible emergency measures becomes key. What is the obligation on states when the ICJ renders an order as we expect it to do so tomorrow?
Article 93 of the UN Charter, the founding document that created these United Nations, says the following. All members of the United Nations are ipso facto, by virtue of, are parties to the statute of the International Court of Justice. Article 94 says each member of the United Nations undertakes to comply with the decision of the International Court of Justice in any case to which it is a party. And of course, Israel is now a party to this case. Let's listen to what Professor Larissa van den Herik of Leiden University, she's an expert in international public law, had to say about the obligation on states in terms of the implementation of a court order from the ICJ. Watch.
The rulings of the International Court of Justice are indeed binding on the parties to the dispute. And if they are ignored, the Security Council may step in to give recommendations on how to enforce them. And there can also be a role for the General Assembly. The fact that Israel is also appearing before the court already shows that it will not ignore the ICJ fully. It has an interest in trying to show the world that it wants to comply with international law. It wants to participate in the international legal order.
And Iman, because we're not talking about some broad, vacuous notion of international law, we're specifically talking about the 1948 Convention on Genocide, to which both South Africa and Israel are signatories. Key to this is Israel showing up with a large legal team to defend itself against the accusations brought by South Africa. So they've certainly given early indications here that they recognize the jurisdiction of the ICJ. So one hopes, therefore, that parties to this dispute will certainly implement the judgments of this court.
The journey to this decision tomorrow, Sherwin, certainly has been an educational one on so many different aspects around humanitarian law and also kind of laying bare, as you shared with us right at the very beginning, where these international allegiances and alliances lie on so great an issue. And we'll see how the chips fall tomorrow. We will carry that coverage live on the SABC at 2 p.m. Central African time. SABC News Correspondent Sherwin Bryce-Pease, thank you very much for giving us a view from the US and the UN.